Some common law rights presumably lie so deep that even Parliament cannot override them. And we know from Tolkien that the dwarfs delved too greedily and too deep, and we know what they awoke there, a Balrog to destroy our freedoms of right and kill Gandalf! Not Gandalf! Hello and welcome back to Uncodified. In this episode we will be exploring the labyrinthine subject of the rule of law in the UK. We apologise for not having this episode out sooner, but there has been much chaos afoot in both of our households.
Originally, the third episode was meant to be on common law, but the task of describing it in an approachable manner and keeping it brief was challenging to say the least. So in this episode, we're doing the rule of law. We will define the doctrine and talk about its importance to democratic societies, as well as its development over the last couple of hundred years.
So, like in our separation of powers episode, we will explore the prominent theorists on the subject, in this case AV Dicey, and look at modern interpretations. We will look at the role of the courts in restraining the actions of the government to uphold the rule of law, and where the courts sometimes fail to do so.
Dicey writes a ton on the rule of law, with chapters on how it affects the right to personal freedom, freedom of assembly, martial law, the army, and taxes, and the responsibility of cabinet and other ministers, and how it contrasts with the sovereignty of Parliament. But this isn't a lecture on Dicey, so we are going to limit ourselves to his views on how the rule of law is an important part of our constitution. And later on, we will briefly look at his views and how it interacts with parliamentary supremacy.
A lot of law textbooks and journal articles on the subject refer to Dicey's law of the Constitution as the orthodox traditional view of what the rule of law is. So instead of just regurgitating the textbooks, we should evaluate the source directly.
So what is Dicey's idea of the rule of law?
Well, I'm glad you asked, Charlotte, for I've written much on this subject. Dicey argues that there are three ways in which the rule of law is an integral part of the English Constitution. First, that there is an absence of arbitrary power, that nobody can be punished without having been found to have broken the law in a process of a normal court. He compares this to his contemporary Europe. He's writing in 1889, where he argues that even though the rule of law had improved, the government of every continental power had wider arbitrary powers of arrest, detention, and expulsion than existed in England.
When you consider the nature of the governments of Germany, Austria-Hungary, the Ottoman Empire, Tsarist Russia, and even Belgium under Leopold II, this is not a nationalist brag, but a fairly accurate point.
To highlight the point that the rule of law is an essential characteristic of the English Constitution, Dicey goes back to Voltaire, a French philosopher who visited England and wrote on the government. Voltaire believed that he had left the land of despotism to a country where the laws might be harsh, but where men were ruled by law, not by caprice.
In France, the arbitrary power which the king wielded was not a result of a bad monarch per se, but a feature of how the government was run. Dicey acknowledges that a country following the rule of law is not necessarily a more lenient state. He uses the example of the fall of Bastille during the French Revolution, which was heralded as the collapse of a lawless power despite the fact that it only held 10 prisoners at the time, while simultaneously England held hundreds of people in prison for debt. This was similarly the case when the Peter and Paul Fortress fell during the February Revolution in 1917. The symbol of repression actually held very few prisoners.
The second feature he highlights is legal equality. When we speak of the rule of law as a characteristic of our country, not only that no man is above the law, but what is a different thing, that here every man, whatever is his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of ordinary tribunals. And it seems to be also clear that despite the lack of grammar, he's been very well acclaimed. This can be summarized in the fact that even the Prime Minister is equally accountable for their actions as any other citizen, that individuals are personally responsible for the actions they take in an official capacity if they break the law in doing so, whether they are a colonial governor, secretary of state, or a military officer.
Dicey's third point, the rule of law's place in the English system of government, is that the general principles of our Constitution, such as the individual freedoms and right of assembly, have emerged from the decisions of judges deciding on the rights of individuals. Essentially, our rights come from common law.
At least before the Human Rights Act of 1998.
Yeah.
Yeah. He contrasts this with other countries where the civil rights are found in the general principles of the Constitution. His point is that the English Constitution wasn't created in one moment or as a result of legislation. The Constitution is instead judge-made. He claims that even our statutes are written in such a way by the High Court of Parliament that they are, in effect, judgments. And we will cover the idea of the High Court of Parliament more in the fourth episode, on medieval parliaments.
Dicey uses this to draw a line between the declaration of rights that might be found in any number of constitutions in France or Belgium and the ability to enforce those rights, which may be severely lacking. In the forming of the British Constitution over centuries, solutions have been found for enforcing specific rights. Dicey argues that while the Habeas Corpus Act doesn't define rights, the process that they provide for allows the courts to guarantee hundreds of rights and liberties.
Now, what he is distinguishing between at this point, without really mentioning it, is two different systems of law. Common law, which originated in medieval England, and civil law, which has its roots in ancient Rome. Now, one system is where the judges make law, and the other is where they apply already codified law. I'm making this point because Dicey argues that the US system, where there have been clearly defined rights and a codified constitution and Bill of Rights, follows the rule of law. He argues in a really odd way that the Petition of Right in 1642 and the Bill of Rights in 1791, which were voted on by their respective legislatures and became codified declarations of rights, were really judicial condemnations of claims or practices on the part of the Crown, which are thereby pronounced illegal. Previously he classified the constitutions of France and Belgium as not quite adhering to the rule of law on the basis that constitutions in themselves do not have the mechanisms to enforce the rule of law. He's basically ended up arguing sideways that the rule of law is only present in the common law system, because he's trying to write himself out of a corner that the UK and the US, despite having clearly codified rights like continental powers, follow the rule of law, while also trying to claim that continental countries don't. Experts today would not accept the argument that countries that follow the civil law system do not follow the rule of law.
The concept of the rule of law has, not surprisingly, evolved significantly in the last 135 years. Big changes in our Constitution, for instance the Human Rights Act and the European Convention of Human Rights, has given us codified system of rights in addition to the judge-made rights which Dicey describes. Nor is there in the same way a High Court of Parliament, as all official judicial powers have been transferred to the Supreme Court, with the possible exception of impeachment, which hasn't been used in well over a century.
A big focal point of the rule of law in recent years is the Constitutional Reform Act of 2005, which among other things created the separate Supreme Court. The first line of this statute is, this act does not adversely affect the existing constitutional principle of the rule of law. Unhelpfully, however, the statute does not define the rule of law and only stresses the importance that the Lord Chancellor and other ministers uphold the independence of the judiciary and must not seek to influence particular judicial decisions through any special access to the judiciary.
The Constitutional Reform Act was in fact so unclear on this that the House of Lords Constitutional Committee commissioned a paper from none other than Professor Craig from University of Oxford, an expert on constitutional, administrative, and European Union law. Craig argued that a core point of the rule of law is that governments have to be able to show that their actions have a basis in law, whether that's statutes, common law, or prerogative powers, and if the government cannot do this, the courts should consider this action unlawful. He argues that it is necessary for a law to be passed by the proper method, but there are some laws which are passed by democratic governments which may not comply with the rule of law.
The vague nature of the Constitutional Reform Act, which Charles thinks is definitely not a recurring feature in this episode, also encouraged Lord Bingham, a former Supreme Court Justice, to write a journal article on what the rule of law is. He argued that the rule of law is made up of 8 sub-rules. Firstly,
Firstly, the law must be accessible, so as far as possible clear and predictable.
Second, that questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion.
Thirdly, that the law should apply equally to all, save to the extent that objective difference justify differentiation. Differentiation.
And don't worry, we'll explain what all these mean in a minute. The fourth criteria is that the law must afford adequate protection of fundamental human rights.
Fifth, means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which parties themselves are unable to resolve.
Point number 6, ministers and public officers at all levels must exercise the power conferred on them reasonably in good faith for the purpose for which the powers were conferred without exceeding the limits of those powers.
And seventh is that adjudicative and the seventh is that adjudicative procedure provided by the state should be fair.
And Lord Bingham's final point is that the principle of the rule of law requires compliance by the state with its obligations in international law. The law, which whether deriving from a treaty or international custom and practice, governs the conduct of nations.
We're going to take this point by point and explain what he means. The first point is quite clear that because everyone is required to follow the law, they have to be able to understand it. This has been made a part of UK law through the European Convention of Human Rights case Sunday Times versus United Kingdom, which I will quote. The citizen must be able to have an indication that is adequate in the circumstances of the legal rules applicable to a given case. A norm cannot be regarded as law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able to, if need be, with appropriate advice, to foresee, to a degree that is reasonable in the circumstances, the consequences which a given action may entail.
So Bingham recommends that to ensure clarity, judges should only provide one opinion in appellate cases, rather than each judge writing a different argument to reach the same conclusion, because in some cases you might have 11 judges all agreeing that the case should go one way, but have 11 different reasons for why that case should go that way, which makes it very hard to allow for precedent in future cases. Also, judges should be careful to limit their judicial activism so as not to breach Article 7 of the ECHR and create new crimes that didn't exist when the act of trial occurred.
The second sub-rule seems more complicated on the surface. What he is saying is that to avoid arbitrary decisions where a judge or government official has discretion, it has to be defined narrowly and be able to be justified. For example, a judge has discretion in deciding whether to admit evidence provided by prosecution and on the basis of how it was obtained, decide whether this evidence might affect the fairness of the trial. But the way that the statute giving this power is written is that if the judge believes the evidence to be unfairly gathered, they must refuse it. So judges often only have discretion in one way.
So Bingham's third sub-rule is maybe the most important, that while there is a room to make legal exceptions for some categories of people which the law applies to differently, such as children, the mentally ill, or prisoners, writing laws that apply to people based on their skin color, gender, or hair color would be in breach of the rule of law. Laws that are designed to apply specifically to an individual are completely incompatible with the rule of law. But throughout English and British history, laws have been passed which have actively discriminated against Catholics, Jews, and women. Bingham also points out that this isn't just history, as he quotes Lord Scarman, that habeas corpus protection is not limited to the British citizens, and at least since the Somerset case in 1772, every person within the jurisdiction enjoys equal protection of the law.
Bingham pointed out that Parliament has breached this in its Anti-Terrorism Crime and Security Act of 2001, which allowed for the indefinite detention without charge of foreign nationals suspected of terrorism, whilst exempting citizens who were suspected. When referring to this appalling lack of equal application of the law, In the US post 9/11, he refers to Justice Jackson in the Railway Express Agency Inc. versus New York case, which I will quote again, that there is no more effective practical guarantee against arbitrary and unreasonable government than to require that the principles of law which officials would impose upon a minority must be imposed generally. Conversely, nothing opens the door to arbitrary action so effectively as to allow those officials to pick and choose only a few whom they will apply legislation and thus to escape the political retribution that might be visited upon them if large numbers were affected.
In fact, it is now the case, as shown in the Shmuma Begum case, that individuals who are perceived to be able to claim citizenship in another country, who are in practice from ethnic minority groups, have had their citizenship stripped for involvement in terrorism, which is not only in violation of international law through Article 8 of the 1961 Convention on Reduction of Statelessness, which states a contraction state shall not deprive a person of its nationality if such deprivation would render him stateless. It is also opposed to the rule of law, as those whose grandparents were British citizens now seemingly have more protection than those citizens whose grandparents are from Bangladesh or elsewhere in the Commonwealth. It's also in breach of the rule of law, as under the British Nationality Act of 1981, the Home Secretary has the right to remove citizenship in the case of threats to national security, but not if this would result in the individual becoming stateless.
In terms of the human rights point, Bingham acknowledges that this is controversial. For instance, Professor Raz and other academics have argued that a non-democratic legal system with sexual inequalities and racial persecution might in principle conform to the requirements of the rule of law better than a legal system of a democracy, and that the law could introduce slavery and still yet comply within the rule of law.
He takes umbrage with this position as it contradicts the UN Declaration of Human Rights, that human rights should be protected by the rule of law, and the European Court of Human Rights, which is a direct source of UK law, which has stated that the notion of the rule of law is the basis from which the whole convention draws its inspiration.
The European Commission, at this time Britain was still a European Union member state, considers democracy, the rule of law, and respect for human rights as permanently tied together. And so a state built on persecution and discrimination, even if it is legal, cannot be considered as upholding the rule of law. Nevertheless, Bingham takes the position of Professor Jowl that not all human rights are protected by the rule of law. For example, while the US is not in compliance with the UN Convention on the Right of the Child by using the death penalty for crimes committed under the age of 18, this is nevertheless in compliance with the rule of law as they have not ratified the treaty, and the issue has been determined by the Supreme Court in Roper v. Simmons.
The fifth point means that in order for a law to benefit everyone, and if access to the court is a basic right, litigation should be affordable. This was originally addressed by the Attlee government by instituting legal aid. At the time Bingham was writing, legal aid had already been significantly reduced, especially in civil courts, which deal with cases between individuals. Since 2005, the situation has only gotten worse. As part of austerity, legal aid was cut significantly through the Legal Aid, Sentencing and Punishment of Offenders Act in 2012. This has had a very real impact across large areas of the UK, as low to middle income people can no longer afford good legal advice and representation in court to resolve wrongs which might negatively affect people in areas such as employment, housing, welfare, and immigration.
Sub-Rule 6 would seem self-explanatory, but clearly as Boris Johnson seems to play hopscotch with this rule, he might benefit from a closer look. This rule is based on the idea of judicial review, that the courts have always had a role in restraining government. It is especially important that the judiciary holds the government to account in times of perceived threat to national security, as the government tends to push to the very limits of what it thinks its powers are. In crises, governments tend to slightly overreact, and historically courts have been bad at restraining them.
So, Bingham refers to two cases, R.V. Halliday in 1917 in the UK, where the court where the courts acquiesced that the vaguely worded Defence of the Realm Act allowed the government nearly unlimited power for the duration of the war, including the right to detain citizens without trial, bypassing the Habeas Corpus Act without officially suspending it, and basically ignoring the Magna Carta and the Bill of Rights. The second case is Korematsu versus United States, which affirmed the US government's right to detain Japanese American citizens in a concentration camp for the entirety of World War II, purely on the basis of their ethnicity.
Seventh, this sub-rule is based on the idea that justice must be seen to be done. Judges must be, in quotes, independent and impartial. Independent in the sense that they are free to decide on legal and factual merits of a case as they see it, free of any extraneous influence or pressure, and impartial in the sense that they are open-minded, unbiased by any personal interest or partisan allegiance. Bingham sums up the core principles of a fair court as the following. 1. That a case shouldn't be decided until both sides have been heard. 2. That people should know the charges against them. 3. That the prosecution, or in civil cases, the accuser, should make available information to the defendant that might help their case or damage the prosecutions. And 4. A defendant must have the assistance of a professional in court. The rule of law and the independence of the judiciary are intertwined. The idea that judges in a criminal case cannot be directly influenced by the executive is of utmost importance.
The eighth sub-rule is really what it says on the tin. The only thing that Bingham adds, apart from some quite ironic quotes from George W. Bush, is that, like the protection of human rights, this sub-rule is fairly new. Bingham provides examples of how both sides in the First World War were cavalier with international law, but that between the Suez Crisis and the 2003 Iraq War, the importance which the government places on the legality of the invasion, whether or not it was actually legal or not is another matter, dramatically increased. Whether the government cared that it was legal or not mattered. So now we're going to look at how the rule of law doesn't necessarily correspond exactly with the idea of democracy or a republican form of government. Bingham highlights that the rule of law has a long standing in our society and can be found in the works of Locke. Wherever law ends, tyranny begins. We covered Locke enough in our last episode, so we're not going to torture you with that. So today we're going to look at another figure mentioned by Bingham, Thomas Paine.
Thomas Paine is one of the foremost figures of the American Revolution. His book, Common Sense, was a bestseller and was like pouring the Gulf oil spill on the kindling of discontent in Britain's North American colonies.
Whilst I might annoy a number of Americans for saying this, and whether or not that's my goal, I won't tell you, the ideas that Paine uses are very British. This was the case for most founding fathers, but even more so with Paine, because he was born in Sussex and only emigrated to Philadelphia in 1774 at the age of 37.
Unfortunately missing the inventions of Philadelphia soft cheese by only 98 years.
Anyway,
Paine
was a firebrand. His view on the rule of law can be encapsulated in this quote: "But where say some is king of America, that so far as we approve of monarchy that in America, the law is king. For as in absolute government the king is law, so in free countries the law ought to be king, and there ought to be no other."
Essentially, he is arguing that the rule of law can only be present in a republic. Earlier in the pamphlet, Paine argues that the difference between the absolute monarchy of France and the constitutional monarchy of Britain was negligible, as the will of the king is as much of the law of the land in Britain as in France.
This is wildly inaccurate. As mentioned by Dicey earlier, Voltaire faced a number of injustices at the hand of the French system. For example, he was arrested and imprisoned for a poem that he did not write and did not agree with and didn't know the author.
If any of you viewers are interested, the poem is called La Henriade. It may also be of interest to you that he actually did write it. Make of this as you will.
Yeah, you can't always trust Dicey. He's not always there. This is why we've got to be a bit more careful. But he was also arrested for complaining that a duke had let him get beat up by thugs. Or in fact, the duke actually ordered him to get beaten up by the thugs. In general, French monarchs had the ability to use letters de cachet, which could imprison anyone for no specified reason for an undetermined length of time with no process of appeal. Furthermore, when Paine was writing in 1775, the Estates General, which is the French Parliament, hadn't been called since 1614 and wouldn't be called for another 14 years. In France, the statement of Louis XIV that le State c'est moi is very much still in place at this time.
In contrast, in England in the 1700s, the king did not have the ability to declare law, and the courts repeatedly used to challenge actions of the governments that pushed the boundaries of the rule of law. The quintessential example of this is Entick v. Carrington, 1765, in the Court of Common Pleas. Entick was alleged to have written seditious pamphlets, and 4 messengers carrying a warrant from the Secretary of State, Earl Halifax, broke into his house and seized his papers. In response, Entick sued the messengers for trespass. The case is a massive deal in common law and affects an awful lot, so to oversimplify drastically, the judge, Lord Camden, ruled that the defendants failed to justify their actions according to the law, as the Secretary of State did not have the power to issue such warrants to, in quote, break open doors, locks, boxes, and to seize a man and all his books, at first suggestion of libel.
The warrant which Carrington and others were using was executed at the first instance without any previous summons, examinations, hearing of the plaintiff, or proof that he was the author of the supposed libels. A power which hadn't been claimed before by any magistrate, the warrant also supposedly allowed the messengers to seize the papers, which included bank bills and private correspondence, without Entick present, with no way of knowing what was happening, which basically would mean that he basically would have thought he'd been robbed. Without knowing that the government was involved. The judge's view on this was that no such law ever existed in this country. Our law holds the property of every man so sacred that no man can set his foot upon his neighbour's clothes without his leave. If he does so, he is a trespasser. If he will tread upon his neighbour's ground, he must justify it by law. The jury ruled in favour of Entick, and he was awarded damages.
This is a clear-cut example of the actions of the wrongful executive action being addressed by the courts and restrained in future to the rule of law. Further irony to Paine's claim is that Entick v. Carrington was used as the model upon which the Fourth Amendment to the U.S. Constitution was based. The Fourth Amendment forbids the unreasonable searches and seizures, sets out the prerequisite for obtaining warrants, and specifically mentions the security of houses, papers, and effects. This was the affirmation of a right in the US that had been upheld almost 30 years before in Britain and 10 years before the Boston Tea Party. So the next time you salute your flag over in America, think of us tea drinkers who gave you these ideas in the first place.
You're going to get shot when you go to America. When Dicey explained the absence of the rule of law in Europe historically, the first point he raises is that the rule of law is not necessarily linked to democracy. He refers to de Tocqueville's 1836 comparison between Britain and Switzerland, where he says England seems to be more republican than the Helvetic Republic. De Tocqueville's reason was that in Switzerland, freedom of the press was very new, and most cantons people were subject to arbitrary arrest. The courts were not completely independent, there was no trial by jury, and in many cantons, political rights were less than 40 years old. An especially important difference between the British and the Swiss is that the Swiss did not have the same sense of justice and respect for the rule of law as the British, and that if their republican system was destroyed, the loss of liberties would be quickly adapted to. De Tocqueville would disagree with Thomas Paine's characterization of the British political system, to say the least. And now we shall look at the rule of law versus the sovereignty of Parliament.
So, Dicey's opinion on the rule of law and the sovereignty of Parliament was that instead of standing opposed to one another, the two pillars of the Constitution support and reinforce each other. Dicey's argument that the three parts of Parliament, the Crown, the Lords, and the Commons, had to act together, and that avoids one body changing the law unanimously, and that judges will only interpret the words of the statutes and not speeches or resolutions in either house, and so the law will be what the three institutions have agreed on. He is making an argument that the separation of powers between the three mean that Parliament will not be able to pass statutes which would undermine the rule of law. He states that Parliament, except during the British Civil Wars and Glorious Revolution, has never wielded executive power or appointed officials of government.
So he describes the right of the Common to designate the PM and the Cabinet as a recent acquisition, which is very telling about when he's writing, that Parliament cannot give orders to the military, civil service or police, that because Parliament cannot do this, the sovereign Parliament cannot interfere with ordinary law in the way that a sovereign monarch might be able to. He also raises the point that the removal of judges requires the agreement of both houses of Parliament and that they are independent of every other state apparatus. When laws are passed, they are subject to interpretation by judges who might manipulate the meaning of a statute to conform more with common law principles, which Dicey thinks will blunt the force of any act of Parliament that might inadvertently overstep the rule of law.
Earlier in the text, he argued that parliamentary sovereignty has no legal limits. He uses the example of the Septennial Acts in 1716, in which Parliament, or more specifically the Commons at this time, extended its own term of office by 4 years, out of fear that the Jacobites, at the time the opposition, might win the election. This in itself overturned an Act of Parliament which set the term for 3 years. And in this sense, it showed that no statute has any constitutional authority than a future one which might replace it. Many of the other examples he uses take place in the 18th century, where acts of indemnity were passed to make actions legal that were legal when taken place.
But as we saw earlier when Dicey merged the idea of common law and the rule of law, while he's an important source, he isn't the arbiter of absolute constitutional truth in the modern day. The problem that Dicey has, apart from a very loud dog, is that the idea of separation of powers between each House of Parliament and the monarch is falling apart at the time he is writing, as we saw in the last episode.
That Parliament does not wield executive power in the way he describes is true. But in the modern era, the executive in practice controls Parliament, especially when there are large majorities in the House of Commons, such as with the Thatcher and Blair governments. This could lead to a situation that Lord Hailsham described as an elected dictatorship, where the executive can change the law in ways which might challenge the rule of law. The idea that Parliament can do anything doesn't mean that it should, like that time you ate gum from the ground when you were 7. Speaking to the viewer. If a Parliament tries to pass an Act of Indemnity today, it would cause an almighty kerfuffle.
Constitutional law textbooks like Turpin and Tomkins highlight a number of sources which suggest that to uphold the rule of law, Parliament may have to have legal limits, as the political situation within Parliament that Dicey envisaged to restrain action in a way that would contravene the rule of law has changed dramatically, including the electorate, the Lords' veto, and the makeup of the House of Lords, through, amongst other things, the Representation of the People's Acts in 1918 and 1928, the Parliament Acts of 1911 1949, and the House of Lords Reform Act of 1999.
The idea that no statute is any more constitutionally significant than another would seem to be upheld in Alistair v. McGlennon, 2023. The argument made by Alistair and his associates was that the Northern Ireland Protocol, which was part of the withdrawal agreement, was in breach of certain constitutional statutes, namely the Acts of Union 1800, which mandated equal legal status for Ireland and Great Britain, and that the Northern Ireland Protocol did not allow for the equal footing in trade. The legal arguments addressing this claim are 34 pages long, but put simply, the Supreme Court ruled that other Acts of Parliament that had been passed in 2020, which allowed for the government to negotiate the withdrawal agreement on the basis it would become law. The implication being that a parliamentary act can authorize the government to ignore other aspects of statutes without those other statutes having to be repealed.
This does not mean that there are no statutes of great constitutional significance, but that as the current Parliament is sovereign, it cannot be stopped from passing a law on the basis that it contradicts another law established by a previous Parliament, which is sensible because otherwise Parliament would very soon be unable to pass any laws whatsoever.
The idea that Parliament is sovereign in an absolute sense has been challenged in the 90s and 2000s by common law radicalism. Lord Falconer, besides having a very cool name, argued that the rule of law was both national and international, and that a breach of the European Convention of Human Rights would be in breach of international law. He also argued that the rule of law goes beyond the letter of the law, and that there were constitutional principles that if Parliament sought to overturn would also be in breach of the rule of law. For example, if Parliament tried to abolish elections, it would be opposed to our Constitution, and that it would break the rule of law, which of course puts some challenge to the idea of a sovereign Parliament.
Lord Falconer's position is linked to common law radicalism, which is an idea that has been used to challenge the absolute sovereignty of Parliament. Common law radicalism argues that the entire constitution evolved from the common law. In other common law jurisdictions like New Zealand, judges have questioned whether the Parliament in Wellington has the same authority as that in Westminster. Judge Cook stated, "I do not think that literal compulsion to answer questions from an official, by torture for instance, would be within the lawful powers of Parliament. Some common law rights presumably lie so deep that even Parliament cannot override them." And we know from Tolkien that the dwarfs delved too greedily and too deep, and we know what they awoke there, a Balrog to destroy our freedoms of right and kill Gandalf! Not Gandalf!
Additionally, Lord Wolfe, another person with a very cool name, wrote in a journal article that if an Act of Parliament was passed to remove judicial review of the executive, that, in quotes, that the court would also be required to act in a manner which would be without precedent. I myself would consider there were many advantages in making it clear that ultimately there are even limits on the supremacy of Parliament, which it is the court's inalienable responsibility to identify and uphold. He envisaged these limits to be those which would be needed to preserve the rule of law.
It is also quite often the case that judges will interpret a statute liberally where there is a risk that an act of Parliament might overstep constitutional principles. So Judge Laws, the aptly named fellow, argued in Roth versus Secretary of State for the Home Department that in its present state of evolution, the British system may be said to stand at an intermediate stage between parliamentary supremacy and constitutional supremacy.
As we have seen, the rule of law is not tied to common law or to the idea of representative democracy, and definitely not tied to a republic. Shout out to you American viewers. Although we strongly agree with Bingham that human rights and the rule of law are closely interwoven, almost to the extent that judicial independence and the rule of law are.
There is also an idea which is fairly controversial that there are things Parliament should not do. And while these have yet to be tested, and I hope that they never are, it is my personal belief that there should be limits to parliamentary sovereignty, especially when the only real power resides in the House of Commons, and that these limits to restrain the government from interfering with the independence of the judiciary, along with other basic democratic principles, are necessary to upholding the rule of law. And it should be the rights of the courts to do so.
We have covered a lot of theory today. So well done for making it through the last 30 minutes, and make yourself a nice cup of tea, relax, and think about the dangers of elected dictatorships.
Goodbye, guys.